What's up, everybody? Welcome back into another episode of The Lawyer You Know. And we've got another trial that is not Karen Reed. We are going to be talking about in today's video. Karen Reed's probably going to have to wait till tomorrow for our daily update, which will be Saturday, which will be a nice Saturday morning live, which we haven't done in a while. That should be fun. But today we're talking about Lori Vallow Daybell's motion for new trial, where she accuses the jury of misconduct, the prosecutor of misconduct, the judge, everybody. Everybody screwed up Lori Vallow's case, according to Lori Vallow. But do any of her arguments have merit? Is there any risk of a new trial for Lori Vallow Daybell when it comes to Charles Vallow? Because we know a second trial where Brandon Boudreaux is the victim is about to start in Arizona. That's coming up next. We'll call it trial 2 or 3 or 4, depending on how you want to look at it and how you want to count all these trials against Lori Vallow. But we're going to read this motion together, dig into it, and see what she's arguing about. Make sure you guys hit the like button. Make sure you let me know if you're still following this case, even with Karen Reed and Diddy and everything else going on. And we will continue to cover it if you're interested. So hit the like button and let's go. All right, so we have this motion for new trial that we are going to take a look at together. She filed it about a week ago, May 1st. So a little over a week ago, she filed it. A lot of you have probably already read it. A lot of questions came in about it. We're going to answer those today. Lori Daybell requests that the court grant her a new trial. This motion is filed pursuant to the protections provided by Rule 24.1 of the Arizona Rule of Criminal Procedure, the Fifth Amendment Due Process Clause of the United States Constitution, and Article 2, Section 4, and Section 24 of the Arizona State Constitution. This motion is accompanied by the following memorandum of points and authorities. It sure seems like she's getting a lot of help from advisory counsel, right? Sure seems that way to me. First, juror misconduct. On April 28th, 2025, it came to the attention of this defendant's advisory counsel. So she's basically telling us what advisory counsel told her, and later the court, that juror 15 made a statement indicating he had knowledge of this defendant's prior conviction. Exhibit 1 clip from Fox 10 News. We watched this together. We discussed this together. We said, did it sound like he said that? He definitely backed up and kind of corrected it or answered later that, he didn't know. Nobody knew about the convictions prior to the deliberation starting. I believe this is juror 15. I think this is the same one that said he was not guilty until the last day. Did he go home? Did he do research and come back and change his vote? He also indicated here we go. He also indicated that he was leaning toward not guilty vote up until yesterday and through deliberations. This prior conviction involved the homicide of her children in Idaho in 2023. This defendant did not testify in this trial, and this conviction was not presented by the state as Rule 404B, other act evidence. Thus, juror 15 should not have learned about this information. Absolutely, she's correct. Absolutely, if juror 15 knew about this, that is a major and catastrophic problem, and we have to know about it, and she should get a new trial, in my opinion, if that juror went home, did research, found out about the conviction, and came and changed his vote. Now, did that happen? I don't know. Because this case was a high-profile matter, once the jury was released from its admonition, jurors were free to speak with the media. During an interview, juror 15 was asked about his reaction upon learning about this defendant's prior convictions. He stated the following: I feel sorry for her. Driving home yesterday, I was like, she's spending the next 3 lives in prison in a cell. He's given, I think, multiple interviews at this point. I haven't seen all of them, so I don't know if he's clarified. I assume when the state responds, they may have already responded. I haven't seen the state's response. When they respond, if he has made other statements, maybe they'll add those in there for context. Maybe the state has talked to him. Maybe they haven't. Maybe the judge will call for a juror interview, bring him in, ask him, when did you actually know about this? And hopefully he would tell the truth about that. I think that he would. And if he didn't know about it when they were deliberating, it's a no-go. This is a non-issue, never going to get overturned just by making an assumption or having a juror that, was caught off guard. They were very clearly caught off guard to me when they were interviewed on the courthouse steps, which is always a little risky, but you can't hate on journalists trying to get information. We all want to know information. I'm not a journalist at all. I mean, we, the public, want to know information, and journalists have a duty to go and try to get us that information. And that's what they were doing. But it did give me a little cringe when I first heard it, not going to lie. Preclusion of Tylee Ryan, and there were other statements, I think, that If I was writing this motion, I may have had it in here as well from some of the other juror interviews. Preclusion of Tylee Ryan and Alex Cox statements and impermissible expert testimony by Detective Daniel Kuntz. Prior to trial, the court precluded this defendant from presenting to the jury any of Tylee Ryan's or Alex Cox statements. Yeah, that was the correct legal decision. Both of these people were present during the shooting of Charles Vallow, and thus some of their statements were not hearsay as they show effect on the listener pursuant to Arizona Rules of Evidence 803. Kind of sounds like you want to use them for the truth of the matter asserted based on just that one statement. The state filed a motion in limine throwing a blanket hearsay objection over the entire statements. The court indicated in a pretrial ruling that it would, at least to Alex Cox's statement, take it on a statement-by-statement basis. That's because she did not cause Alex Cox to be unavailable. It's held against you when you cause a witness like Tylee Ryan to be unavailable, which legally, Lori Vallow has done that. During trial, this defendant was precluded from even discussing that Alex conducted a walkthrough, much less his statements, with Chandler police detectives during the walkthrough. So again, some of that is different, right? What did he do? You ask certain witnesses, they can testify to that. What was he thinking, or what was he making clear, or what was he saying? Certain statements can come in, certain statements can't. Just because he is unavailable does not mean all of his statements come in. There has to be an individual ruling on individual statements, in my opinion. Then, in the state's case in chief, it elicited expert testimony from the scene agent, Detective Daniel Kuntz. This defendant objected to his testimony as an expert witness based on lack of foundation and her not having had time to rebut his professional opinion. The judge gave her, that's the problem. It's unfair to Lori Vallow and to defendants to be, pushed and forced into stuff without being prepared. But the judge over and over gave her as many chances as she wanted to stop. Let's continue the case. Take your time. Nobody's forcing you to go this fast. You have demanded a speedy trial. Nobody else is forcing you to come this quickly. She denies that, wants to have her speedy trial rights, and now she's trying to balance what's fair and what's not as far as her speedy trial and what she's able to do to prepare. That probably cured the defect, though, legally. Again, this defendant was precluded from discussing Alex Cox's, the shooter's, walkthrough that was conducted with several Chandler police detectives, including Detective Kuntz. This walkthrough was precluded as inadmissible hearsay. However, it formed the basis for Detective Kuntz questioning with the medical examiner and how he then investigated this case. As Alex Cox indicated, he shot the victim in self-defense. So she just kind of gave away why she's going to lose. Because if I, as a lawyer, was going to read this, I could think, yeah, that makes some sense. She's making some sense. There are some statements she should be able to get out from Alex Cox. But she didn't put any individual specific statement in here that she wanted to get out that should have come in and was wrongfully precluded as inadmissible hearsay. Usually you've got to do that if you want to win. But instead, what does she say? Alex Cox indicated he shot the victim in self-defense. That's not going to be admissible in this scenario in how she wanted to ask it. That is up for the jury to decide. And they didn't get into, was he scared? What made him scared? What was Charles Vallow doing? And things like that that could be considered, your reasonable fear that your life was in danger or serious bodily harm or someone else in the near vicinity was. Next, a discovery violation. On April 14th, 2025, during trial, Ms. Trina K produced a hard drive containing the grade key information from Charles Vallow's cell phone. The contents of the hard drive are exculpatory evidence. The defense had been requesting this evidence so that she could provide it to her independent expert for his review. This discovery disclosure occurred in the middle of trial. I think they cured it somewhat, but additionally, they didn't let her expert make the arguments and do the analysis he wanted to because it was in the middle of trial. I think the judge should have tried to find a way to allow this to happen to avoid this appellate issue. I don't think this is going to come anywhere near overturning this conviction and allowing a new trial. Prosecutorial misconduct. On April 8th, 25, the state elicited irrelevant, prejudicial, and improper character evidence when she asked Chandler Fire Department Keller if he overheard any conversations with the defendant. Ms. Trina K asked Captain Keller on direct examination, "Did you overhear this defendant talking with police?" He responded in the affirmative, stating he overheard someone stating not getting invited to a pool party because of the commotion at the house or something. I don't remember that. This statement caught the defendant off guard, as Captain Keller indicated during his interview with Chandler Police just after this incident occurred that he only saw the male outside on the curb and did not mention even seeing the defendant. During closing arguments, while addressing the justification defenses, Ms. Trina K told the jury that this defendant was not entitled to any of the self-defense instructions. Miss Trina K also gave false statements by saying Alex had no reason to be at this defendant's home and that this defendant told Alex to bring a gun. So Lori Vallow has a problem with the way Trina K argued in closing arguments. You are allowed to, as a lawyer, make connections with the evidence, make reasonable inferences with the evidence, use the evidence and weave it into your theory of the case, explain the why, even if it wasn't testified to, a logical why. And to say that Alex Cox brought a firearm to the house, like, well, why did he? We don't know. Well, Trina K thinks she knows, and she's going to argue that she does based on all the other evidence, like we've got to defend ourselves and we've got to be Nephi, that Lori Vallow was the one that told him. You're allowed to make those kind of connections and arguments. Now, if the jury says, no way, that's not what the evidence said, get out of here, well, they don't have to accept your argument. But you're allowed to make arguments like that. Ms. Trina K knew from previous testimony interviews and pretrial defense interviews that Summer had begged Alex to go over to the defendant's home because of Summer's concerns for this defendant's safety. Well, that's fine. But guess what else? Trina K, I would think, believed that Lori Vallow was the one concocting this whole plan and controlling everybody, including Summer, and getting everybody to get Alex Cox to her house with her firearm to implement her plan. You're allowed to make that argument. You don't have to see the facts the same way as the defense. We know that. Finally, Ms. Trina K commented several times on this defendant's demeanor during this incident. Drive to the police station on body camera and told the jury you did not see her cry in that interview. Yet knowing there were portions of this defendant's interview that had been cut from the full interview admitted by the state, where she sat in the room and did show emotion and can be seen grabbing a Kleenex. So number one, Lori Vallow could have pointed that out. She should have pointed that out. She should have played those portions if they exist. If not, and the judge said, and again, I don't know what was cut, what wasn't. I didn't see what was given to the jury, but the judge said the only things cut from that interview were inadmissible hearsay, and everything that was admissible went back to the jury. So either number one, whatever she wanted to play was not admissible, or number two, it was on the video, on the interview. The jurors said they went back and watched it. And it didn't help Lori Vallow for them to watch it. Either way, there's nothing inappropriate with what Trina K argued based on this information. The court's lack of impartiality. So the juror, the prosecutor, and the court, all problematic, all reasons Lori Vallow needs a new trial. The court precluded this defendant from presenting a defense by striking her witness, including but not limited to Nate Eaton and Brandon Boudreaux, before they were ever called to the stand. Specifically, before testimony began, the court required this defendant to establish on the record what relevancy her witnesses would present. This required this defendant to state in front of the prosecutor her defense strategy. This is not required under the law or any rule of evidence. That's not true. You do have to show why somebody is materially relevant, especially if they are a journalist or a reporter and you're going to try to sequester them, right? And especially if they are a victim of yours, an alleged victim. During cross-examination of a civilian witness, Serena Sharp, in relation to testimony regarding religious beliefs, the court commented during the prosecutor's objection to relevancy, stating, "I guess to the extent that you are comparing yourself to these biblical figures, I will allow it." Probably shouldn't have said that. I agree with Lori Vallow here. I'm trying to find spots I agree with her as well. Probably shouldn't have said that. Nowhere near reversible error. Part of the state's case was to establish that this defendant had stepped outside of the Mormon religion by claiming she was a translated being, specifically in text messages, saying she would be like Nephi, and that these messages were nothing more than part of the conspiracy to kill Charles Vallow. This defendant attempted to establish that being translated was a regular part of Mormon religion and thus a relevant line of questioning. Additionally, she didn't really say much about these witnesses, but she didn't serve them properly, so the judge legally didn't have to allow them to have to be called to testify because of that reason. And number two, didn't find they had anything relevant to testify about in this case. She should have, in this motion, put what was relevant that the judge was wrong about. That's what she should have done if she wanted to argue this appropriately, but she's a layperson. She's a criminal defendant. She is not a lawyer, although I do think advisory counsel probably helped. All right, argument and authority. The Arizona rules of criminal procedure provide that a court may grant a new trial when a juror or jurors have committed misconduct by receiving evidence not properly admitted during the trial. Additionally, A new trial is appropriate if, for any other reason not due to the defendant's own fault, the defendant has not received a fair and impartial trial. So I do agree with her. If she can prove, and maybe the judge will find it's enough for a juror interview to talk to juror number 15 and get to the bottom of what did he know and when, because that's the only real legitimate argument I feel she has in this entire motion that, if she is correct, would grant her a new trial. This defendant is entitled to a new trial because the jury received and consulted extraneous evidence. Once a defendant shows the jury received and consulted extraneous information, prejudice must be presumed. I agree. And a new trial must be granted. I agree. Unless the state proves beyond a reasonable doubt the information did not taint the verdict. In State v. Poland, the court held that since the federal convictions were based on the same series of acts as were at issue in the state prosecution, evidence of the prior convictions is inherently prejudicial. Yeah, I would think so. When a juror does not base his verdict on evidence developed at trial, he violates the fundamental integrity of all that is embraced in the constitutional concept of trial by jury. Such misconduct by jury members denies criminal defendants their rights under the 6th and 14th Amendment to confront and cross-examine his accuser about that extrinsic evidence. This defendant's advisory council and the court both received evidence that the jury's verdict was tainted when Juror 15 spoke during his interview with Fox 10 News, disclosing that he had learned of her prior conviction seemingly one day prior to the admonition being lifted. Because it is clear, Juror 15, and that's the problem, I don't think it's clear. Juror 15 had information he was not entitled to know prior to conducting deliberations. The burden is on the state to prove beyond a reasonable doubt that this information did not taint the verdict. The state will not be able to meet this burden, and this defendant is entitled to a new trial. Even if an offending juror may not have influenced the other jurors, unanimity is required to convict a criminal defendant, and the juror's conclusion may have been different had the juror not consulted extraneous sources. And with this juror specifically, they mentioned they were not guilty and then ended up being guilty, with the mentioning in between that she had other convictions. In Cornell, a juror looked up definitions that were neither admitted into evidence nor included in the trial court's instructions. The juror testified that he was confused and undecided about the allegations, and his reference to outside sources made his decision that the defendant was guilty. Clearly a problem. Reference to dictionary definitions by jurors is usually considered a harmless error. However, the appellate court found that this was not harmless error and that the defendant was entitled to a new trial. Because, again, in that case, and we don't have to go as not really anything to do with Lori Vallow, but the state's job is to make sure the jury understands. They should not have to go do outside research. They should not be allowed to go do outside research of any kind, even if it's simple. Similar to the juror in Cornell, Juror 15 stated he had information neither admitted into evidence nor included in the trial court's instructions. Even more egregious than in Cornell was that this information learned was that this defendant had prior homicide convictions. There's no doubt about it that's prejudicial, right? We've talked about it the whole time in this case. As in Poland, this information is inherently prejudicial as these prior convictions directly related to this prosecution. And they heard Tylee's name throughout, wondered why they didn't hear from her. And then if you find out, oh, well, Lori Vallow ended her life, well, that's obviously going to be prejudicial. There's no argument there. The only argument is, what did he actually know and when did he know it? At the time of writing of this motion, because, and by the way, the reason I didn't say, and did it affect his verdict, is because I would presume it affected his verdict if he knew she was convicted of multiple homicides prior to voting guilty. At the time of writing of this motion, it is not known if Juror 15 shared this information with other jurors. However, what is clear is that Juror 15 did not follow the admonition and notify the court of him having learned of this information, so an inquiry could have been conducted prior to deliberations. These actions directly violated the court's instructions and could have factored into Juror 15's verdict, if not multiple jurors' verdicts. In fact, Juror 15 noted that up until the day of closing arguments, he would have voted not guilty. Given this, the state is unable to prove that Juror 15's misconduct did not taint his and potentially other jurors' verdicts. I agree. The state will not be able to overcome the overwhelming evidence of Juror 15's misconduct in order to prove beyond a reasonable doubt that Juror 15's misconduct did not taint the jury. Accordingly, this defendant is entitled to a new trial. By the way, this is going to come back to the age-old question. Do we want jurors doing interviews? And people may say, no, we want to protect the verdict. I would always say yes, because if he actually did do this, she should get a new trial. You guys know how I feel about Lori Vallow Daybell, right? She's not my favorite person. But even she has to have her rights protected. Even she needs a fair trial. Even she needs an impartial jury who follows the rules, follows the judge's admonition, doesn't go outside and do extra research. Because guess what? Put some other defendant in Lori Vallow's chair. How would you feel if this is actually what happened? I'm not saying it did. I don't know that it did. But he definitely made comments that would make you think it's possible. She's not pulling this completely out of left field. He did make some corrections. Maybe the judge needs more information. Maybe there are more interviews out there that give it more context that the prosecutor can use, but that is a potential problem. And if it exists, I'd rather know about it than not know about it, right? What kind of person wants to say, no, we don't want to hear about the problems? It's like, no. We hope there are no problems. If there are, we should know. Preclusion of Tylee Ryan and Alex Cox's statements. And because the court allowed expert testimony without a Rule 702 ruling that this defendant is entitled to a new trial. The new trial is appropriate if, for any other reason, not due to the defendant's own fault, the defendant has not received a fair and impartial trial. By precluding Tylee and Alex's statements, this defendant was prevented from presenting part of her defense at trial, and thus she did not receive a fair and impartial trial. The court made a pretrial ruling that, at least to Alex Cox's statements, it would be a statement-by-statement ruling. Instead, this defendant was even precluded from discussing Alex Cox's statements during the walkthrough. These walkthrough statements formed the basis of Detective Coons being able to testify as an expert, yet she was precluded from cross-examining him on this foundation. For this basis, the defendant is entitled to a new trial. And again, I mean, that's just literally repeating what she already said. Discovery violation, fair and speedy trial, great key evidence. State's discovery violation was 1, the importance of the evidence, which the defendant was deprived cross-examination, the right of confrontation and proper investigation. The state manifested the surprise and prejudice to the opposing party. The violation was motivated in bad faith, which neither the court nor the state corrected, and the many other relevant factors that the state saw fit to depriving the defendant of her constitutional right and statutory rights. So we'll see if the appellate court thinks giving Lori Vallow the opportunity to continue the trial and waive her speedy trial right in order to do this appropriately, and she said no, is that enough? Acts of prosecutorial misconduct entitles the defendant to a new trial. Same kind of introductory paragraph. It's improper for a prosecutor to misstate the law or evidence during closing arguments. I agree. To misstate it, not to make an argument or disagree with the inferences you believe was made by the evidence. Ms. Trina K stated that this defendant was not entitled to self-defense instruction, yet they were clearly provided to the jury. Ms. Trina K also gave false statements in her closing argument by stating Alex had no reason to be at this defendant's home and that this defendant told him to bring a firearm and extra ammo. Ms. Trina K knew from previous testimony interviews and pretrial defense interviews that Summer had begged Alex. Okay. Lastly, commenting on this defendant's demeanor, specifically stating she did not cry. Okay, we already read all that. So she's saying she knowingly misstated the evidence, which, first off, I don't even think she objected to facts not in evidence or misstatement of the facts or anything like that in closing, which, again, she's not a lawyer. So the judge commenting on the evidence, it's a repetition, ruled 15.2b of the Arizona Rule of Criminal Procedure requires a defendant to disclose for each listed defense other than the defendant that the defendant intends to call a witness at trial in support of the defense. Rule 15.2c1 requires a defendant to list the name and address of each person other than the defendant intends to call as a witness in any written recorded statement of the witness. There is nothing in Rule 15.2 that requires this defendant to present her defense strategy in order to call a witness. She's missing it. The Fifth Amendment to the United States Constitution provides this defendant the right to subpoena power. This preclusion of witness and requirement of this defendant to inform the state of her defense prior to calling any properly noticed witness shows a specific claim of partiality. Were they properly noticed? Were they properly served with the subpoena power she has? So other questions I have for Lori Vallow. Second, for the record established that the court commented while responding to the state's relevance objection, I think is what she means, unless she's agreeing it was a relevant objection. And that comment showed a specific claim of partiality by casting doubt onto the defendant's credibility on this religious issue in general, showing she cannot be trusted. The court commented, I guess to the extent you're comparing yourself to these biblical figures, I'll allow it. This comment is even more important when taking into consideration that Juror 15 in the Fox News 10 clip indicated he ultimately made the decision to vote guilty based on 2 text messages, including one describing, I will be like Nephi. There's no doubt that was a big part. And this was actually a smart argument to connect it to what the judge said, although again, nowhere near enough to grant a new trial. The court inserted its own improper comment when a simple overruled or sustained was warranted. I tend to agree. This in and of itself shows a lack of impartiality and requires a new trial. No, it doesn't. That in and of itself, by definition of in and of itself, does not show lack of impartiality and requires a new trial. It just shows a judge said one sentence too much when granting an objection or denying a sustaining, overruling an objection. Use every single word I can think of. Given the above reasons, this defendant respectfully requests the court grant her motion for new trial. And she attaches a clip of juror's Fox 10 News interview. So we watched it together. I encourage you all to go watch the interview. Tell me in the comments what you think when you see it. Outside of that juror interview, nothing in this motion should scare anybody about thinking maybe there will be a new trial. All of it is proper legal decisions or within the judge's discretion or harmless error that happened and occurred during this trial. No prosecutorial misconduct based on those arguments made in closing. She didn't even say anything about leading the witnesses or anything that we talked about. Might be a procedural issue on appeal, but she stuck to the wrong things outside of the juror interview. That is the one thing that if you gave me more information that was good for Lori Vallow, I think she might have an argument, but I don't have that information right now to say that. So still kind of up in the air. Will we ever get it? Will Lori Vallow ever get it? Let me know what you guys think. But that's all we got. And again, if you're continuing to follow Lori Vallow, please hit that like button and let me know in the comments and make sure you're subscribed because she has another trial coming up. If you're not paying attention and you're just watching Reed or you're just watching Diddy or something else, not watching Diddy, but following Diddy, let me know and we can just pass on Lori Vallow. If you're still following it, still watching it, I'm happy to continue to cover it as much as I can. Probably not daily, but as much as I possibly can. So thanks for being here with me. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a uase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.